actually mute all the others' mics, please.
Teberati, you're muted too.
Dr. Teberti?
Yes, I think I can now be
Okay,
heard.
can you briefly, yeah, you can briefly introduce
Yes.
Dr. Wexler and we can get started, please.
Yes. So all of you, warm welcome and a very good evening. I take this opportunity to welcome you all. I am Professor Dr. Debaruti Haldar from United World School of Law, Karnavati University. And we have with us for this webinar of UWSL-KU, Karnavati University, Professor Dr. David B. Wexler, Professor of Law at the University of Puerto Rico in San Juan, Puerto Rico, and Distinguished Research Professor of Law, Rogers College of Law, Tucson, Arizona. He is an honorary president of the International Society for Therapeutic Jurisprudence. He received the American Psychiatric Association Manfred S. Guttmacher Forensic Psychiatry Award. I'm sorry for my pronunciation. Chaired the American Bar Association's Commission on Mental Disability and the Law, was a member of the panel on legal issues of the President's Commission on Mental Health, and many more. Let me first introduce Professor David Wexler from my side. He had been my mentor and my guru for therapeutic jurisprudence, and we, especially from the university as well as from the India chapter of therapeutic jurisprudence, extend our warm welcome, Professor. And now I leave the stage and also the online stage to you, Professor. Professor, a very warm welcome. Shalom, namaskar, and very good evening from India.
Okay, thank you all very much. Can you hear me? Yeah. I'm delighted to be here. As Dr. Debarati said, we've been in touch for a long, long time. Feel like we know each other, although we know each other only virtually. Never been this close before, right? The box right next to you, at least on my screen. But we're really excited about the Indian chapter of the International Society for Therapeutic Jurisprudence. And we hope all who attend will join the society. We have some information I hope that we can give out at the end, or the website. And we're excited about that. And then, of course, any of you who are from India also to join the India chapter, which is the most recent of a good 10 chapters that we have, with real international involvement. So we're very excited about that. I'm very excited to be here with you. I had spoken with Dr. Debarati about the possibility of, even before this meeting, getting people oriented through an 18-minute video, which is on the home screen of the International Society for Therapeutic Jurisprudence. And it seemed unwieldy to request that people do this and do it from home and do that before they even attended. So I guess the hope now is that we will simply go and show that video to give a background, because I think we probably have people from many different backgrounds here, and with greater or lesser knowledge of therapeutic jurisprudence. This would kind of put everyone on a level playing field to know some of the basics in that 18 minutes. And from there, it would be easier for me to do my PowerPoint presentation that I have planned for you all. So what I'd like to do then is give myself an 18-minute break. I'll still be here listening, but see if we can turn this over to the technological people and see if we can run this video, and then I'll be back with you. So thank you very much.
This thing works. Very good. Well, thank you. Nice to be here. My topic is a bit different, and it will have a law focus, but it is an interdisciplinary approach. Therapeutic jurisprudence really is can be considered a healing approach to the law in general. Our focus today and my main interest is in its application to criminal law and juvenile law. What I'm going to speak with you about now is, excuse me, an international and interdisciplinary program or project that is to try and mainstream therapeutic jurisprudence, meaning to see the extent to which it might be able to apply outside of the context in which it is now best known. The context in which it is now best known is in these special problem-solving or solution-focused courts like drug treatment court, mental health court, domestic violence court, and the like. These are courts that were really designed specifically to allow for a lot of what we do in therapeutic jurisprudence, or what we support in therapeutic jurisprudence, to come into to those courts and to work in those courts. I will try and explain that in a moment. This project is one that is was launched formally through the Hague Institute on Innovating Justice, and part of their platform on innovating justice, and that's where these slides come from. The gist of therapeutic jurisprudence, or the insight of it, really would be that whether we like it or not, whether we know it or not, the law has an effect, often has an effect, a therapeutic or an anti-therapeutic effect. And traditionally in the law and in law schools, surely this has been ignored, the impact of law on emotional well-being. We really urge that it be taken into account, that it be studied, and then ultimately it be factored into our efforts at law reform and at the administration of the law, instead of being simply ignored. It's not to say that therapeutic goals should trump other goals, or should be the only goal, but it is that we should be aware of the therapeutic and anti-therapeutic aspect of our legal actions and of our system. The best website that I'd like you to take away from this is therapeuticjurisprudence.org. The best thing isn't on the slide, but next time it will be. That will give you resources and places to go if you're interested in follow up on this. And my email, davidbwexler@yahoo.com. Very anti-therapeutic to omit the B. So, but if you put in the B and write to davidbwexler@yahoo.com, I'm a good emailer, trust me. Way better at email than at PowerPoint. So this project is really designed through The Hague to have a small group of us, myself, Magistrate Pauline Spencer from Victoria in Australia, from Melbourne, and Mike Jones, who's a former judge in Arizona and now on the Arizona Summit law faculty. We're the ones who really proposed the project in the Hague as small teams of experts who will try and work with interested communities to try and see the extent to which therapeutic jurisprudence might be brought into their legal system. It is, as I said, a very interdisciplinary subject matter that involves lots of psychology, criminology, and social work. We'll talk about that at the very end. And it works with offenders in the criminal law area, with offenders and also with victims. Victims is really, our attention has turned more recently to victims, I should put it that way. It started out mainly with offenders, but there's been very good work now bringing victims in as well. And we have also a Facebook page that is a good resource. Well, as I said, therapeutic jurisprudence has mainly been applied in drug treatment courts and mental health courts, and these are structured so as to invite a number of TJ kind of practices. These are good courts, and these are good alternatives to the traditional criminal. They are part of the criminal justice system, but they're good alternatives to the traditional criminal justice system, and we're very supportive of them. However, what's happening is that though there's been a movement to try and extend the scope of problem-solving courts, that isn't happening all that much. Partly, there are major budget problems that are leading to their constriction, even to their elimination. In Queensland, Australia, some of very successful courts have actually been eliminated for budgetary reasons. So that has led people to say, well, besides that it's a shame, what else can we do? If we can't operate, can we take these skills and this knowledge and apply them elsewhere in the criminal justice system where these people will inevitably go if these problem-solving courts no longer exist? Let's assume, however, that they exist, that they've thrived. There are, as you likely know, serious political and ideological constraints on the front-end admission to these courts in the form of eligibility standards. They are unlikely to be too broad, in other words, to be broadened substantially to let all sorts of people into these alternative methods. And therefore, a lot of these people are going to end up in the ordinary criminal justice system. We've seen here that the jails and prisons are really full of people with drug problems, with alcohol problems, with mental health problems. Michael Perlin, you probably know, who's a leading mental health law academic and advocate, has recently attributed a substantial part of the criminalization of mental illness to some anti-therapeutic Supreme Court decisions. And not the ones that simply bring civil rights that Madeline was speaking about earlier, but rather going back to the 80s in the wake of the Hinckley case and the aftermath of that, and how it changed our culture about an awful lot of matters of mentally ill in the criminal justice system. The U.S. Supreme Court came down with a case called Jones in, I think, 1983, which upheld for someone who was successful in urging the insanity defense, not guilty by reason of insanity. That person was found not guilty by reason of insanity, was committed to a mental hospital, St. Elizabeth's, in fact. It was a local case, and I think the crime was like attempted shoplifting of a coat or the jacket in a department store here. And he pled not guilty by reason of insanity and won, but ultimately his lawyers were bringing his case to the U.S. Supreme Court saying, wait a second, he's been confined forever based on this successful plea. And the Supreme Court, again, I think probably in the wake of the atmosphere of Hinckley, said, well, that's okay. Once you're in the system as mentally ill and dangerous, until you're no longer both mentally ill and dangerous, you can be confined. You're not guilty. It's not a criminal conviction that is limited. And so that rule, obviously, we would look at it as an anti-therapeutic rule in the sense that it discourages people from asserting this defense. People in Jones's situation now don't raise that defense because they're better off in the criminal justice system, for example. And so we are looking to see the extent to which we can bring therapeutic jurisprudence insights into all sorts of stages listed here. Early diversion, of course, bail hearings, plea negotiations and judicial settlement conferences, the imposition of sentence. Many of those sentences can be a community-type sentence, a non-incarcerative sentence, for example, and in post-incarceration procedures and conditional release, parole or its equivalent. Dr. Greenberg spoke of the police. Part of our project does indeed involve police and police interrogation and the newer methods of investigative interviewing, which has been studied. I think it was started by a psychologist named Ronald Fisher some time ago. A lot of work has been going on in Sweden by Ulf Holmberg, who's a police officer turned psychologist and psychology professor, on this type of more humanistic interviewing techniques, both of suspects and of victims. And the research showing that this type of interview, as opposed to the more abrupt, just the facts, ma'am, that may exist in the traditional interrogation method, it produces, according to their research, more important information, and it leads to greater well-being on behalf of perceptions of subjective well-being on behalf of the suspects and of victims. So we're looking at all of these kinds of stages, and when we look at the law, and this is important, we're concerned with the law in action, not just the written law. And when we're looking at the law in action, we're looking at the rules of law, at legal procedures, as well as the roles of legal actors, that is the behavior of judges, of lawyers, and of therapists and others, police officers, working within the legal context. We use this metaphor looking at the rules and the procedures, the actual applicable law, the legal structure, the legal landscape as bottles. And we look at the practices and techniques of legal actors, the roles played by those legal actors as wine. And really what we're trying to do then in this project in the general criminal system is looking at the different bottles across there and seeing to what extent the TJ practices and wine can be poured into those bottles. The practices such as in court, just active listening and giving someone participation and voice and making them feel that they have some voluntary say over what happens to them. All of these kinds of things, we have lots of the wine worked out, and the wine has been used pretty well in the problem-solving courts. Now, if we're looking beyond the problem-solving courts, we look at these other stages of the process. As I said, police interviewing, diversion, criminal settlement conferences, bail, imposition of sentence, conditional release, all of those sorts of stages to see, will they allow these kinds of practices in there? Or, and if so, are they being used that way? Or, because of lack of interest or knowledge or whatever, are they not being used to the extent to which they could be and could be profitably used? And what kind of training would be required of what kind of people to get the law as it is now to work better? And that's an important aspect. Very often we think of law reform as just go and change the law, but we're very interested in the wine as well. Can we work with the existing law and improve it? In the case of police interrogation, for example, there's probably not much law really restricting us from doing it the investigative interviewing way as opposed to the traditional way. In the law itself, you comply with Miranda and do all that. You can then go on with the way in which you would like to behave. So we're looking at bottles that we call either TJ friendly or not friendly. The TJ friendly ones are ones not necessarily that are working well, but that could work well, that have the potential to be filled with the TJ kind of fluid. The ones that aren't capable of having the TJ fluid come in, we think of as unfriendly, and those are the ones where we think of law reform. So an example of pouring better wine into an existing bottle can be seen in a very simple situation of the imposition of probation. Instead of the judge unilaterally ordering probation and its conditions, which is kind of the traditional way, I've thought about this, I'm putting you on probation, here are the conditions of your probation, and that's the end of the imposition of sentence. the judge could begin the process by soliciting the offender's input, asking the offender to personally justify a probationary sentence and the conditions that the offender deems necessary and appropriate: curfew, AA meetings, school attendance, etc. And so this red light is very intimidating. How much more do I have? Very anti-therapeutic. Let's say, okay. When one imposes a sentence, a probationary sentence, there are lots of different ways that one can do it. So this is a TJ-friendly structure in the sense that it has a lot of room for discretion in behavior. And according to the procedural justice literature, the latter way should increase offender compliance and increase a sense of fair treatment. And this is how we learn the TJ wine from our vineyards of psychology, criminology, social work. This has also been used, incidentally, in a paper I wrote a long time ago, in the conditional release of insanity acquittees. If people, despite the Jones case, plead insanity and win and are hospitalized and can be released, usually preceded by conditional release by a court order, judges and the way in which they can conduct those hearings presumably can do an awful lot to increase the sense of fair treatment, to increase offender compliance, and so forth. So the kind of the interdisciplinary nature of this is really for us to look at matters out of the social sciences that can be relevant to the work of judges, lawyers, and others. Relapse prevention planning has been used, like James McGuire's work, reasoning and rehabilitation approach that originated in Canada, Chad Maruna's excellent work on assistance from crime, Mike and Bauman Turk's work on facilitating treatment adherence. They wrote some time ago about in medicine generally, but a lot of that can be applied to psychiatric situations and to legal situations, behavioral contracting, giving voice, giving clear instructions, and condemning acts rather than actors. John Braithwaite's work on restorative justice and so on. So this is kind of what we're doing. I'd be most interested in following up if any of you are. I have cards here with David B. Wexler at yahoo.com. I'd be happy to take your cards, and thank you very much.
Okay, thank you very much. I'm glad we had an opportunity to see that, because I do think it gives us a bit of a common vocabulary as we move forward, and this ties in then with the PowerPoint presentation that I would like to show. I believe once again this can be done at your end, Dr. Deverarty, and I can say when we move from slide to slide. Is that how it will best work? Yeah. Okay, so I'm ready for it. Okay. Good. Okay, so we're talking about here law reform the TJ way, integrating the therapeutic design and the application of the law. And you see the abbreviations TDL and TAL, which is showing how the vocabulary is evolving in therapeutic jurisprudence. Because in the video that you just saw, we spoke about all this, but we spoke about it only in the sense of wine or liquid and bottles. Okay, now that we still use that a lot. I think it's an animating kind of term. Lots of people like it, but there are certain professional situations where we're better off, we think, using a more professionally sounding designation for this. And what's happened then is that we have taken the bottles, the legal structure, and we call that the therapeutic design of the law, or TDL. We take the wine or the liquid or the practices and techniques, and we consider that pouring in, that would be the application, the therapeutic application of the law. So that's just an update really on some terminology that is becoming more and more important. And what's important to say about this is that we're really talking here about a method of thinking. Of course, there's lots of substance to this, and we discussed some of it in the video, but really this is a conceptual framework, a design. I think it's one that is fairly easy to grasp. And once you grasp it, you're going to start seeing these items in other instances, I think. As I said, most of my work has been in criminal law, but we have seen the wine and bottle work and the TDL and TAL work used not only in criminal law, but in immigration law, in eviction law, in child protection law. So this really is a method of thinking, and a method that we think one can take with you in other work. If you're a law student, you may start seeing this in other courses that you're taking. If you're in a legal clinic, you may start seeing your cases in that way. If you're in practice, likewise. So really, we're talking about TJ as being a conceptual framework that you can bring with you. We'll go on to the next slide then. Next, please. Yeah. And this is a simple definition as the law as a therapeutic agent. Again, as I said earlier, whether you like it or not, whether you know it or not, the TJ insight is that somehow or other the law has an impact, often has a therapeutic or sometimes has an anti-therapeutic impact. And we want to not ignore that. We want to be aware of that and then see to what extent we can work with that, either to change the law if it's feasible, or to improve the application of the law if we can do that. So but the law itself operates as a therapeutic or sometimes an anti-therapeutic agent. And when we say the law, what do we mean? We mean the rules and procedures that we've seen, the legal structures, or the bottles, or the structures of the law, the design of the law, and we mean the practices and techniques of legal actors, which is the liquid or the wine. And these legal actors often, of course, are judges and lawyers, but they may be psychologists, criminologists, and others who are working within the legal system, or police officers. And TJ originated really in mental health law, and then it was spread across the legal structure by law professors who taught mental health law, but also taught other topics like criminal law, like immigration law, like family law. They said, what we've learned in mental health law might also apply there. But it began in mental health law. And a big motivating influence for me was many years ago, noting a patient at the Arizona State Hospital, a mental patient at the hospital. And unlike the other people in his unit, in his ward, he was unable to leave the unit and walk around the hospital grounds. He didn't have ground privileges. Why didn't he, I inquired, because he seemed mild-mannered and all that. They said because he was not a voluntary patient, he was an involuntary, court-committed patient. And why was that? it was only because he came from a remote area of the state and had no means of getting to the state hospital, though he wanted to. He realized he should be there and wanted to go. And some people in the home community happened to realize that the law provided free transportation to the state hospital by the local governing agency, by the county, but according to the statute, only for court-committed patients. So the people in this home community said, we can get you to the state hospital, we have to see the judge. The judge ordered the person committed, then he showed up at the state hospital with state-provided transportation. But once there, he was really given a security status and a label that was undeserved, that was higher than what his clinical condition warranted. And so that was something where I started thinking, gee, this is interesting. Mental health law is supposed to help people. And here, in a very, very crude sense, I guess it helped him by getting him into the hospital. But in another sense, it got him there with a higher security status than was warranted, and with a stigma attached because of his involuntary status. So I started collecting things like that, and also areas where the law was very helpful. And before I knew it, I was doing TJ without knowing it, and then ultimately developed the conceptual framework. So the next slide, please. Again, as I said in the earlier video, in many jurisdictions, certainly in the US and Australia and many others, TJ practices are best known through so-called problem-solving courts, or as they're called in Australia, solution-focused courts, which is a term I actually prefer because it shows that it's not the judge just solving the problem. It's the judge facilitating a solution-focused approach. What are these courts? Drug treatment courts, mental health courts, courts like that. Some of these courts originated in the US. Mental health court was explicitly founded on TJ principles by Judge Lerner Wren, who's a member of the ISTJ, International Society for Therapeutic Jurisprudence Board, and she founded it on TJ principles specifically. These courts, again, are set up so that they invite TJ practices. That's their whole purpose, to have the judge actively involved and facilitating a team, active participation by the parties. It's not just all run by the lawyers. Active listening by the judge, having techniques like, let me get this straight. Is this what you mean by this? I want to make sure I understand you. Displays of empathy. These are the kind of liquid, the kind of practices that are used in problem-solving courts. Onward, please. Next slide. So now we are entering the so-called mainstreaming area, or the mainstreaming project. And this is, as I said again in the video, because one, if the courts are working pretty well, we'd like to kind of expand them. But expanding them is difficult because we have severe limitations on who would be eligible. We don't want people in those courts, these front-end diversionary kind of courts, who have a serious prior record or who are charged with serious crimes. And so that becomes somewhat difficult. It becomes difficult, but what it means is that those people still are in the regular system. Can we give them, can we bring to them some kind of TJ practices? And we then have to look at what the different bottle is. These bottles are different from those of problem-solving courts. These are the bottles of the regular criminal justice system. We want to see to what extent we might be able to work with them. Some of them might be TJ friendly in the sense that TJ ready, that they have the potential to use TJ practices. Others don't. Those others that don't have that possibility are ones where we would ask whether there's any kind of fix to the law that's viable, that's appropriate. Sometimes it's not, sometimes it is. So we have some examples here. One of them is a diversion. And here we have something that I would consider a very bad bottle, at least under the US federal law. Not important that I'm picking on the US federal law here. These are just examples that I happen to know. But diversion there it has to be done really by the book. A prosecutor may say, this is a good case for diversion. I would like to put this person on, offer this person a diversionary option rather than going on with the criminal process. But under the federal structure, a prosecutor is very, very limited and must use very, very explicit language in doing it. Lots of legal jargon, wheretofore and hereinafter and those kinds of things on a prescribed form. When we try to ask, well, can you write a separate letter? The answer seemed to be no. You know, if you're going to do it, you do it this way. So it's really not a good bottle, even for a prosecutor who wants to offer it and wants it to succeed. That prosecutor would probably know what to say if he or she were given more freedom, such as, you seem like this is a first offense. You've had a pretty good history up until now. We have a decent diversion program. We think you'd be a good candidate. Would you like to think about it? But that can't be said. And so it's a bad, some people still will be offered and will accept it. And when they complete it, if they complete it successfully, then you're also not allowed to say, to write a letter or congratulations, we're glad we offered this to you. We're glad that this was permitted, and we wish you well. No, it's just something automatic that you get saying, you know, you've completed this and charge is dismissed. So it's a very bad bottle, I would say. Now, other jurisdictions have much looser bottles that are much better, where they can use more of the appropriate liquid. The other one here that I mentioned, criminal settlement conferences. This is a type of judicial mediation, basically. And again, the federal law is bad in the sense that judges aren't allowed to be involved at all in bargaining or resolution out of court of cases. In the state of Arizona, where I used to live, there is a good bottle because it has potential therapeutic application. There, a judge is leading things, and we'll talk a little bit more about what you can do with a good bottle in the next slide. So if you have an existing good bottle, remember, I mean by a good bottle that it has potential, not that it's necessarily being used. It is ready for TJ. TJ ready may actually be even a better term than TJ friendly. It's a TJ ready bottle. Criminal settlement conferences. But because it's a TJ ready bottle doesn't necessarily mean it's being used that way. And so with criminal settlement conferences, we saw in Arizona different kinds of judges using different kinds of procedures. Some of them had criminal settlement conferences, but they were very, very skimpy, just bare bones. There would only be a meeting with the judge and the two lawyers saying, how are you doing on this case? Have you thought about it? Are you trying to settle it? Do you have some kind of bargain? Do you want some more time? Let me know in a week. That would be taking a good bottle, but using it in a very, very minimal way. The other type is a much more robust type. We mentioned earlier my now late colleague, Michael Jones, who was a wonderful judge, and he was often people who wanted to have a judicial mediation settlement conference, often the trial judge would refer it to Judge Jones, who was known as a real TJ judge, and he ran a very robust kind of conference. Very inclusive participation, not just the two lawyers, but also the defendant personally. And if the defendant was invited, the victim would be invited. Family members of each were permitted. It was held in a respectful way, an empathetic way. And as in many kind of situations where we're trying to reach a settlement, there is a potential for apology in the sense that anything said at this will not be usable if we don't come up with a case and it goes back to court. Once we say nothing at this conference can be used against you if we don't reach an agreement and you have to go back to court, that means that there is a potential here for apology, for efforts at apology, for that sort of thing. And so that makes it very, very interesting if you have a robust hearing. Judge Jones told me very often these apologies actually began with a family member of the defendant who would hear the story and say, "Oh my God, I'm so sorry this happened. I really feel bad about this." And before we knew it, there was some kind of apology being made even by the infractor, the defendant, in those kinds of cases. So that was a robust hearing. The point I'm really making here is, again, to show the importance of not just having a good law, because this was a good law, but rather filling that good law with a good application of the law, as Judge Jones did. We also have an example, an easy example of probationary sentencing. Very often the traditional matter, a judge will have some report, perhaps from a probation officer. The judge will make a few words, ask the defendant, you have anything to say, and will then simply go in and say, well, I'm going to order you on probation, and here are the conditions. You will do A, B, and C, and you won't do D, E, and F. And now you're on probation, case over, good luck. And that would be the end of it. But a more TJ approach is that instead of doing it in that very unilateral way, the judge could actively solicit the offender's input. I'm inclined to think about probation in your case, but I need to have a discussion with you about how it would work, how it could work, what kind of things you would want to agree to do and change, what kind of things you won't do. Let's have a discussion about this first. This seems to, from the social science research, increase compliance and increase a sense of fair treatment on behalf of the person being sentenced. This really comes from psychology, and therefore here psychology is a producer of the TJ liquid. Now, many judges are going to do this on their own inclination without any kind of formal training or background in this at all. But the background is there for training sessions on how important it is to involve someone give them voice, to have them play a part, an active part in their sentencing. So that gives an example of the therapeutic application of the law. Okay, next slide, please. Now, usually the bottles don't require a lot of social science work to create them. There are cases, for example, that suggest that if someone is put on probation, it might be nice to hold a follow-up hearing, in a month or two, to see how is the person doing, how are the social service agencies doing, is everything under control? Well, some jurisdictions allow that and some don't. But if it's not that controversial, it would be good to simply change the law to say, yes, we can have some follow-up hearings once probation is imposed. It's not like the judge's role completely must end at that point. So no study was needed to come up with that kind of common sense rule. So too, if someone's on probation and they're doing well, they may be on probation for 3 years, and maybe after 2.5 years, some states will say if someone's doing well, the judge can end probation early. And if the judge can, then perhaps it could be done, and it could be very therapeutic to do it, and do it in a way that's very animating to the person. You've done well. We really want to congratulate you for this. We're glad you have even your family here, because we're going to end your probation now early, because you've shown that you're well reintegrated into the community. Congratulations. So that can be done if the law permits it. Many laws don't. They just don't think about it. They don't say anything. Some laws do, but when they do, many judges and lawyers don't think about it. But the point here is that they could really think about it and use it. The point I was making is that usually bottles are not designed based on legal experiments, but once in a while they can be. And there's one that is very interesting, and it actually is one that followed a federal, U.S. federal law that had basically abolished discretionary parole. Some time ago, the U.S. federal system said, you know, we think it's kind of unfair that we have two people with the same kind of crimes, same kind of sentences, but one of them gets released on parole pretty early. The other one has to wait a much longer time because he or she's not granted parole. We should do something different. We should have truth in sentencing. And a person, when he or she enters prison, should know exactly when the date is that they will be getting out of prison. And therefore, we will abolish discretionary parole, meaning that after you serve a certain amount of time, the parole board can release you on conditions. Instead, but we're not going to say we want you to just go from prison to home with no other supervision. We want to have something, we will call it, instead of parole, we'll call it supervised release. However, it's going to be set by the sentencing judge. The judge who sentences someone will say, I sentence you to 3 years imprisonment, followed by 2 years of conditional release, of supervised release, with the following conditions. All of it is done up front. And there was a state in the US that said, boy, we should modernize our law. Now that the feds are doing it a different way, we should do it, we should follow the modern way. And they too abolished their discretionary parole in the state system and substituted basically what the federal rule was. And someone, an economist, I believe it was, did a study of this before and after and said, you know what happened? Under the new law, the so-called modern law in that state, we have more disciplinary offenses than we used to have under the old law. People punching out their cellmates and things like that. We have fewer enrollments in rehabilitative programs that are voluntary. And we have greater recidivism on release. Why do we have this? Because presumably this new law sapped the system of its motivational influence. You know when you go in, when you're going to get out. And yeah, it might, you know, and you know now that if you punch your cellmate, you know, you may lose some privileges for a little while, but you're still getting out on the date that the trial judge told you you were going to get out. What about enrollment in rehabilitative programs? Well, that could be okay, but it's a lot of work, reading, kind of boring. I'm not going to bother. So you just lay around and don't go to those programs. And not surprisingly then, if those programs are somewhat worthwhile, you have greater recidivism, greater reincidence on release. probably, they didn't measure this, but my guess, a much less rewarding professional work setting too, because people, professionals and guards and everyone working in that system are working with prisoners who are not given any motivation, at least by the law, to comply and to do other sorts of things. So once in a while, you do have the studies that actually point in the direction of how you might design a bottle. Okay. Next slide, please. Now, so that we don't have to get too technical into the law, I mentioned earlier that many of this conceptual framework can be used in lots of different settings. I mentioned immigration law, child protection law, eviction law, things like that as well. Well, one really easy one to grasp without people who may not have an extensive legal background are certain types of administrative settings. And this came from a study out of Canada where there was a criminal injuries compensation board. That is, people who were involved as victims in a criminal matter. Some of them will do nothing about it. Some of them will try and sue their assailant as a civil action, but usually there are not a lot of hope for real recovery from an offender personally. And so a number of jurisdictions have set up criminal injuries compensation boards where someone who's been injured can come to the board and prove their medical expenses and how they lost some time at work, what they've lost, and seek some kind of compensation from these administrative personnel, administrative law judges or the equivalent. Not a court setting, really. It's supposed to be just informal, sitting around a table and so on. So there were some TJ researchers in Canada who decided to look at how this system operated, and they were looking at the liquid here. I mean, how this is set up. People have to fill out forms and come in and have a bit of a hearing. How are they getting voice? Are they given validation, respectful treatment, all of these sorts of things? And the survey showed that lots of people didn't feel they were. They felt that the evaluators were rushing them. Let's get on with it. Let's cut to the chase. In essence, they weren't really getting voice. They came in, they wanted to tell their story, and they were hurried and didn't feel like they did tell their story. Being able to tell your story seems to be a very important element in how people feel about how they've been treated, how fair it is, and all of that. And many of them felt that this system was not giving them a real sense of fair treatment. Beyond that, that's a lack of voice. Also, we have validation. Validation means that the trier of fact or whatever, the judge, is going to pay attention to what you have to say. Well, these cases were begun by forms that took a lot of time to fill out. And sometimes claimants felt that the forms hadn't been carefully read. There was a lack of validation. So it came to hearing, and the arbitrators would ask them, so remind me, what's this case about again? What happened here? And they feel deflated that they really weren't given, that they spent a lot of time and energy and hard work trying to fill out these forms and make them clear. Some people aren't all that great at filling out forms and at writing and all that. So it was a real struggle. And then what for? The people that hadn't even basically read it. So that's a real lack of validation. What this also shows is how important a matter like form reform and form simplification can be to increasing access to justice and claimant satisfaction and all of that. So in the most simple ways, these things are important, as is signage in courtrooms and all of that, making things simple, making them clear. I think Professor Deberardi has written about some of this in some of her work on courts. So this is just an example in a simple criminal injuries compensation board situation. Next slide, please. Also, the whole environment is important. So if you're going to have nice judicial officers or administrative officers there, but if the receptionists are rude and nasty and all of that, that's going to affect things very much. So too, some of the administrative law judges like the idea of maybe sitting up higher than the claimant, or having a flag and having a kind of court-like settings, even though this isn't a court, and even though very often these people were trying to avoid the whole notion of a court. They avoided the adversary system, and yet the way it was set up, it kind of seemed a bit intimidating, like a court. So here you have flexibility. You could have a non-threatening private room, you could have water, you could have tissues available, and it would be much more accommodating to the people. Next slide, please. Now, in these administrative settings, very, very clearly, it's the administration, the application of the law that's usually crucial here, the liquid. But sometimes the bottles can be important, so that in Ontario, I believe it was, there was an amendment that said when originally the victim, when they filed a claim for compensation, had the choice: do you wish for the offender to be notified, yes or no? And usually they said no. This is just us and our injuries that we want to prove, and we're coming here because we don't want to confront our offender in a court setting. And yet, somehow or other, an amendment was passed that required notification to the offender instead of leaving the choice to the victim or the claimant. Now, I'm not sure that many of these offenders came or had any interest in coming, but what it did do was it discouraged the claimants from even bringing this claim if they thought that this might lead to the offender showing up at their hearing, and some may avoid using it. So here, the bottles weren't generally important, but in this one sense, it was, and it was in what turned out to be a negative sense. Okay. Next, please. Okay. Just something, because this involves so much of criminology, sociology, and all that. I just wanted to mention, in criminological terms, some of you may be very involved in that. You know something about the risk, need, responsivity theories, and some TJ people. I note Martine Evans here. I should have also mentioned Astrid Bergden here. Both of them have written about this actually independently. They say, you know, you can think of it this way. When you can think of the law, if the law consists of the design of the law and the application of the law, we can think of that in criminological terms as external responsivity factor. We talk of responsivity in an internal way, that is, what is the individual offender or client? How is that person built? What is that person most receptive to in terms of therapeutic programs and all that? But there's an external responsivity factor as well. And the law can be a really important motivating influence or not, as we saw with the federal system of parole. It's not a motivating system, but the other kind of system is. And what about the application of the law? We know that if judges are very matter of fact and not making eye contact with offenders and not introducing themselves and not trying to pronounce names correctly, you may be reducing the amount of motivation that you have. So you can think of the law, TDL and TAL, as an external responsivity factor. And I think this could be a very useful way of bringing TJ law really closer to criminology and having them work together in that way. Next, please. Okay, now I'm going to do something on building on what we talk about voice, validation, respectful treatment that I spoke of earlier. A lot of people feel that procedural justice, which is just what I said it is, it's giving people voice, validation, respectful treatment. It's a branch of psychology. It's a very useful branch. It's a branch that is really really accepted completely by TJ. But a lot of people have been confused and really think procedural justice is therapeutic jurisprudence. And it's important to realize that procedural justice is accepted fully by TJ and is an important initial building block of TJ. And it's way better than if we didn't have it. This voice, validation, respectful treatment. It leads to a sense of fairness. It leads to greater compliance. We have literature on that from people who study procedural justice. But it's important to ask, when I've been at some meetings and they think that okay, well, we have TJ in our court because we do this and this and this, and all they're talking about really is procedural justice. Well, that's a lot better than if they weren't according and talking about procedural justice. But they shouldn't think that because they know something about procedural justice, that's it, that they don't need any more thoughts about TJ. So what I want to do is first show something about tests for procedural justice itself. Procedural justice, as I said, has been connected to how people feel about their treatment in court, whether they were heard, and whether they're likely to comply. These things are really important. And some social scientists have wanted to try and reduce procedural justice to testable kinds of criteria. So in the next slide, we see some tests for procedural justice that were from the literature. There are a number of them, but they're similar. So what they may do is either sit in on court to see whether someone is accorded procedural justice, or they may interview court users afterwards to see, and they would ask questions like this. At court today, did you have enough opportunity to tell the judge what you think he or she needed to hear about your situation? Did the judge seem genuinely interested in you as a person? Did the judge treat you respectfully, fairly? Are you satisfied with how you were treated and dealt with? So one could just imagine if you're a judge, say, and you know you want to do something, you want to do procedural justice, and you come across something like this, or a social scientist teaches you about procedural justice, and they show you this, and then you say, okay, I'm going to sprinkle this into my court hearing. So in the next slide, we'll see, guided by procedural justice alone, this statement could earn high marks. And I'm not saying that this is bad. This is really a very good statement. But I want to show you later on that I think it's not that it doesn't take care of everything. So here, Ms. Smith, I want to make sure you fully understand what we're doing in court today. Please raise your hand if you need for me or for someone else to speak up or to clarify anything. And when it's your turn to speak, please take your time and don't be nervous. I'm here to make sure we have all the important information and that we've taken into account all the factors you regard as important. So I think that's good. It's a great start. If every court did it, we'd be in much better shape than we are now. Okay. But the TJ Vineyard includes procedural justice, but it goes beyond procedural justice. There are other insights that come from psychology, criminology, and social work. What are some of these? Relapse prevention planning, which is like rewinding a situation to see what went wrong and how to avoid these high-risk situations in the future. So when I say procedural justice, I say procedural justice gives voice, but TJ adds voice as to what? What are we actually talking about besides saying nice things and appropriate things to the court user? What else? So here, relapse prevention planning, rewinding it to see what went wrong and how you can avoid high-risk situations. Or certain healthcare compliance principles that were developed for doctors. Greater compliance with medical advice, or it turns out with legal orders, if a friend or family member is aware of a promise. Compliance is enhanced if the person is asked to summarize the agreement. Do you understand what it was all about? Compliance is enhanced if the person is asked to suggest how this new time will be different. And there are many more. The list keeps growing as social science keeps growing, condemning the act but not the actor, reinforcing and praising positive efforts, those sorts of things. Okay, so a richer, more nuanced judicial dialogue that's guided by the Vineyard might read something like this. Now, it would also sprinkle in the other stuff that we spoke about earlier. But Ms. Smith, I'd like you to tell me about when you've gotten into this situation of driving while intoxicated in the past. Were you alone or with others? Which other people? People your own age or older people? Was it daytime or nighttime? In your neighborhood or elsewhere? These are important because very often they're going to show, especially with young people, that they were doing it not when they're alone, but when they're with others and others of their own age and at nighttime and matters like that. So you're getting this kind of stuff out. Now, Ms. Smith, this is an important point. So please think carefully about it. What do you propose to avoid getting into this situation in the future? Here's my concern. This didn't work last time. Why do you think it'll work for you now when it didn't work for you a year ago? Are there changed circumstances? If so, what are they? What's different now? Okay, now, when you were in court last time, you mentioned that you would like your Aunt Sylvia to be in court with you next time. Is she here today? Can you please tell her slowly and clearly so she will easily understand and remember what you've now promised to do so that this behavior won't happen again? Now, these sorts of things, if we, let's just go back again to that last slide. These are trying to ask you things. You're still treating the person respectfully, very respectfully, but you're not just talking about giving voice generically, in general. You're more focused on certain things we know from the social sciences, from relapse prevention planning, from healthcare compliance literature, from other kinds of literature. And we're trying to weave something so that the person himself or herself will get an idea of why we may be imposing certain kinds of conditions now. Say, if we're going to give probation, but we say, okay, so you're only going to drive with with parents or alone. I'm sorry, or when you're going to and from work. What's different now? You're saying this because if there are changed circumstances, you want the person to really think this didn't work last time. Why is it going to work now? Because now I'm married, now I have a job, now I have a kid. You want them to think that, you want them to say that, and that's going to presumably help them really on their journey to comply. So too, if you're able to summarize what you intend to do now with someone else in the courtroom, you don't want to let them down. You want to be able to, one, to show that you understand what you're agreeing to do and that you're conveying this to someone else so they will understand, they'll know what you promised to do. This also should be helping your performance and your compliance in the future. Okay, now we can go on to the next. So if we have a TJ-friendly bottle, how could this kind of dialogue be used? Well, if we're imposing a probationary sentence, this would be a more therapeutic application of the law than a judge simply unilaterally imposing conditions based on a pre-sentence report. If you have this kind of dialogue, it's going to be more important. It's important also to realize that the manner of imposition of sentence is as important as the actual sentence imposed. The manner of imposition is crucial under TAL, under therapeutic application of the law. So here you might have that dialogue, and then the judge might say, okay, well, let's see if we have some agreement here. What if I give you probation, but you agree only to drive under these circumstances, and you do this and you do that? Are we coming up with something? It seems like it's more of a bilateral agreement than simply a unilateral mandate by a judge. That's because also probation usually is a pretty TJ friendly or TJ ready provision where you can have this kind of dialogue. I ought to mention though that I've spoken to some people from some legal systems that are a lot more rigid, I would say, in adhering to statutes as written in a literal sense than might be the case, say, in the U.S. So I had a long dialogue with some people from a Latin American country about this sort of thing, and it said, well, wait, it says the judge shall impose conditions of probation. And they therefore think the judge should be doing it, their instinct might be that the judge should be doing it alone without this dialogue. And yet, we would say, certainly in the US, and I suspect in many, many countries, if you think about it, but there's nothing here that says that before the judge imposes sentence, the judge can't have a dialogue with someone that might inform the judge about these conditions. But there may be an inclination on some people, if it's not laid out that way in the law, to just think the judge does this, it's the judge's job and nothing more. It's just a caveat that I'd like to mention. Okay, that's the front end. What about the back end when one is to be on parole or conditionally released from prison? Well, as I mentioned earlier, the US has the federal system where conditions of later release are imposed early by the sentencing judge at the time of sentence. So under that system, that federal US system, the bottle would not be TJ friendly, and this kind of good TJ liquid and good dialogue couldn't be used when someone is in prison and we're trying to talk with them about getting out. If it were a discretionary parole system, a parole board might use those kinds of questions and decide whether to let someone out, and if so, under what conditions. But under a system where everything is set by the sentencing judge at the time of the imposition of sentence, we know what kind of wine we would like to use, but we can't use it because there's no bottle to hold it in the US system. The US system would be a candidate for therapeutic design or redesign of the law. What about a system that exists in many European countries and Latin American countries where there's a separate judge for the application or implementation of sentences. One judge imposes sentence, but then matters go to a separate judge for the implementation of that sentence. That judge technically has the right to work or to discuss with the offender how the person's doing in prison, how they're progressing. Eventually, that judge can offer the person a kind of conditional release later on, and even have follow-up hearings. They can have this kind of dialogue. They can do all of that. Well, what I found is that if you have a system like that, and if the judge is using TJ a lot, procedural justice plus more, they would be able to do this in imposing a conditional release later on in that kind of European or Latin American kind of system. But the irony that I found when I first got into this was that when I got into this issue of reentry, was that the U.S. had plenty of the liquid, plenty of the techniques, but it had no place to put them at the end. And Europe has a good system to use these kinds of things where a judge can be involved with an offender and can do this, but in fact, they weren't that into or aware of the kind of TJ practices and liquid that were being used elsewhere. Now there's kind of an effort to bring these things together. So I think we basically have, let me see here. Yeah, concluded this. We have a resource page that I wanted to update, which is the next page if it's still with this package. Eliminate number 2. That is no longer here, and Dr. Deberardi will give you the reference to the International Society for Therapeutic Jurisprudence, which has the biblio, which has everything, which has all of that. We have a really good blog, TJ and the Mainstream blog. We have several other resources that are mentioned here. We have a good Facebook page. Now we have a Facebook group that I would suggest that people join. As I say, number 2 is now, it should be really www.intltj.com. intltj.com. And that would be, that would give us the reference to that. So thank you very much. Let me see here. Yeah.
Okay, thank you so much, Professor. I was basically, I was glued to the entire session, and I think that we have got like participants who are also the members of Therapeutic Jurisprudence, International Society of Therapeutic Jurisprudence, and also I got to see that members from the police have also joined in. So thank you so much for your wonderful session. If any participant has got any question to clarify, to ask to Professor, please feel free to either put it in the chat box, or you may also ask by unmuting yourself.
I would simply like to emphasize that if you think this is worthwhile, that TJ is an ongoing type of enterprise. Joining the ISTJ is very important, and having these different resources and feeling that you're part of a community nationally and internationally that is working on these issues. Things are happening all the time in many different areas. So I've been involved with lots and lots of different people in different countries, and it's very easy. The TJ community is very accessible, really, and the TJ listserv is an excellent resource. There are many excellent resources. So it's, as I say, it's not just a packet of materials to learn and memorize and apply, and that's it. It is ongoing with discussion, with new developments. And I'd be very happy to be in touch with you all. I look forward to seeing you on the TJ listserv, on the ISTJ, in the India chapter, any place else where you may be. But and I'm a good emailer. I said David B. Wexler at yahoo.com. I'm a pretty good emailer on that. So
Yeah.
I'm happy to put you in touch with others or to try and refer you to certain literature. So I'd be very pleased to be in touch, and I'm very grateful to have this opportunity. I'm very happy that the India chapter with Debarati's leadership is on its way.
Thank you, Professor. Thanks to my university and thanks to my management that they had arranged for this webinar. So with this, I will not take much time because I understand that Professor Wexler, it is morning time for you, and for many other participants who may have joined from other jurisdictions also, you may have different timings. So with this, I end this session. If the participants would like to know anything about International Society of Therapeutic Jurisprudence, you can email me personally. And also for any other clarifications, Professor Wexler is there, as Professor Wexler is giving his email ID also. Again, thank you, Professor Wexler, and thank you all the participants, esteemed participants, faculties, students also. I think that this session had been very useful for all of you. And also, I would like to mention, Professor, especially for you, I have started in Karnavati, in India, Karnavati University is the first university where we have included TJ, even though in a very small package. So we are training our students, especially the final year students and also the criminal law students, about the effect of TJ for victimology and also for criminal procedure, criminal law, etc. So I hope that this session would be very useful for all the students and also the faculties and the researchers. With this, I thank you so much, Professor Wexler, and all the other participants. Thank you so much, and a very good morning to Professor Wexler, even though it is going to be a good evening from all of us. Thank you so much.
Thank you again, all of you.
Thank you. Professor, you can leave the session now if you wish, because I know that this is morning. Thank you. Thank you so much.